Thank you, Mr. Chairman. I just might say parenthetically that I'm unaware of anyone who is suggesting we just go back. There are differences, but I think that's a straw man, that hypothetical. I have a few questions, but first I'd like to yield a minute to my colleague from California to follow up on some earlier comments made in the chairman's questioning.
I thank the gentleman for yielding, and I'll be very quick. Mr. Director, I just want to follow up on the chairman's questions at the outset. I don't think the chairman was asking how often you've attempted to get a warrant on an American, which I think you stated that you've done about 100 times, but rather where you have gone up on a foreign target but have had the effect of overhearing the conversation of American. How often has that happened? And I think you said you'd get the number back to us, but I wonder if you can tell us today, are we talking about hundreds of conversations, thousands of conversations, or tens of thousands of conversations?
Sir, I simply don't know. I mean, I just don't know. We'll get the number and provide it.
I would think as the director, you ought to know what ballpark we're talking about, even if you don't know the specific number. Do you have any objection?
I'm not even sure we keep information in that form. It'd probably take us some time to get the answer. The reason is you're collecting information. It's in a file. It will roll off in a period of time. You may not even know it's in the database. That's one of the reasons we're so careful about who has access to that database.
If I could, do you have any? If I could just, because I don't want to take up too much Mr. Berman's time. Do you have any objection, Mr. Director, to an amendment to the Protect America Act that would provide that when you do overhear the conversation of an American, even though you're targeting a foreigner, that you will report those conversations to the FISA court, that the FISA court would have a supervisory role as well as the Congress? Since that would be done on the back end, it wouldn't provide any time obstacle or anything to the surveillance on the front end. Would you have any objection to that kind of amendment?
Sir, all I would say is when I was trying to get out earlier, when you're collecting information, think of it as a broad area targeting foreign communications. More often than not, you don't even know that communication's in the database. So it might, and I don't know, be happy to take a look at it, it might create a situation where it creates significantly extra effort on our part. Don't know, but happy to take a look at it and consider it.
Just reclaiming my time. How do you know, if you're minimizing those conversations, how come you wouldn't know? How do you minimize without knowing?
If you look at it, then you know. But
so all you do is minimize the ones you happen to look
right,
at.
if there's something in there that it doesn't come up for some reason, you just wouldn't know. That's what I was trying to make the committee sensitive to.
Mr. Weinstein, it seems to me there's a fruitful area that, based on your letter to proceed in. I want to make sure I understand. You state that the bill we passed does not give you the authority for physical searches of homes, mail, computers, or personal effects of individuals in the U.S., and you won't use it for such purposes. There are people who are concerned about that. As part of being able to do what you need to do, would you have any objection to as part of a permanent or a subsequent authorization prohibiting, making clear that that is not authorized? Was there any problem with that? That which you have asserted without qualification is not allowed.
Right. I've been asked that question a number of times. Well, if that's not a problem, if you don't read the statute to allow that, then why not go ahead and put some sort of proviso in the statute that says it's not allowed? And as I said, we're perfectly happy to see any proposed language you might have. You've got to keep in mind, though.
Maybe we'll just take it from your letter.
Keep in mind, however, sir, that every time you put language in, you see here you're talking about authorizing language that you think, or that some people think, might have unintended consequences. Anytime you put limiting language in, you got to make sure that that doesn't have unintended limiting consequences. So it have to be looked at very carefully.
But you're open.
But I'd be happy
you're open to that avenue of pursuit. You state collection of business records of individuals in the United States because they, quote, concern persons out of the United States. We may want to make clear we will not use this provision to do so. I guess I have the same question. You don't think this provision authorizes collection of medical or library records for foreign intelligence purposes?
No, well, there's no hesitation there. No, my reading of this statute is it does not permit that. Medical records.
And then I have the same question regarding a bill that would make people feel more comfortable about this and at the same time not alter what you think the bill that passed in August does.
We'd be happy to take a look at the language there, yes.
And third, the issue of reverse targeting. I notice here you say the government cannot. In other places you say the government will not do it. Here you say the government cannot and will not use this authority to engage in reverse targeting, the targeting of a U.S. person by your interest is in the U.S. person, but you talk to a foreign person because the U.S. person you think will be communicating with him. Is there some subtle reason, or did you just decide to use a new formula when you added cannot to will not in that?
That might have just been a little rhetorical flourish. I'm not sure. Maybe I just wrote that late at night. But I think the point was very clear. We cannot under the statute. That's not allowed. When we direct surveillance at somebody in the United States under FISA, under the pre-existing definitions of FISA, we cannot do that without a court order.
So,
and we will not do it.
It would just seem to me, as part of giving you the ability to do what you need to do, and having the American public, or that part of the American public, and the members of Congress that are concerned about other authorities, a fruitful avenue to pursue jointly would be to clear the underbrush out. Those things that you don't think you're authorized to do and aren't seeking authorization to do, we specifically and affirmatively indicate clearly you can't do.
Perfectly happy to engage with you on that process. And I guess I would just say,
a healing process.
in the context, though, of the recognition that there is ample congressional oversight, there's FISA court oversight, and you've got our commitment that we're not going to do anything, and it would be against the law to do the reverse targeting as you just described.
I don't feel overwhelmed with the ampleness of the congressional oversight at this particular moment, but
Part of it.
We'll be briefing you at any time you ask.
I reassert my position.
Sir, we feel overwhelmed right now with the number of visits we've had since the 5th of August. But could I just comment, if I would? Where we got tension in the system last time is people were adding words and we didn't have a chance to examine them. So this unintended consequence thing is very important.
I appreciate that, and that is an argument for what I'm suggesting as well.
Right.
Because there are other people who fear consequences. They won't even assume that they were unintended. They think they may have been intended consequences, but you're up here telling us in writing and in person they were never intended, and we want to dispel that concern on that side.
And my point is if we can sit down and walk it all the way through, examine each word and understand it and accept it, then that's perfectly acceptable to the administration.
Very good. Thank you, Mr.